Supplementary list. Announcement of judgment, item number 1.
Order, not judgment.
Announcement of orders.
This court, on hearing the parties at length, has given anxious consideration to all the arguments that have been advanced. Firstly, is noted that writ petitioners approach this court against the threatened action of the creation of additional central bonded warehouse in the state based on the averments contained affidavit filed with the respondents dated so-and-so in WC 186, which is contempt and gross violation of Meghalaya bonded warehouse and excise rules. On proof of affidavit filed in the said writ petition, it is noted this averments contain para 3 thereof, and it appears a decision was made on recommendation of technical committee, which have been constituted on 59/23 to examine functioning of central bonded warehouse in the state, with a further mandate that a committee was to ensure that no monopoly practice is practiced at the central bonded warehouse level. The subsequent chain of events thus led the petitioner to approach this court by way of the incident petition, though the larger issue with regard to legality in the virus or the amendments made to the excise bonded warehouse rules are still pending adjudication in WC 186. The petition therefore seeking this court to fear the decision of government based on the recommendation of the technical committee. At this juncture, we would opposite to refer to the challenge with amendments in the rules when a petition has been arraigned as a party respondent with a successful tender and IIT dated 17/11/2020. This court notes that objections to the incident petition raised against the proposed action by state respondents setting up additional central bonded warehouse in the state is already on record in the detailed affidavit filed a petition WPC 186. Annexure 15 to the present petition. A perusal affidavit reflects that the petitioner has placed on record in the writ petition the factual aspect which has also been placed in the present writ petition, which has, however, been further embellished and expanded submissions on points of law, along with additional pleadings questioning the justifiability of the action of the state respondents. This court is factual backdrop, though compelling arguments have been advanced within the senior counsel, Mr. D.K. Mishra, touching upon all the vital issues, together with discussion of the legal doctrines and efforts made to distinguish the situation of the present writ petition as opposed to WC 186/2021, pending for the division bench. In a considered view of this court, however, the adjudication instant matter for a single bench can be acceded to. As for discussion and observations made, then escapable facts as the instant matter intrinsically and intellectually linked with writ petition so and so. As such, in order to avoid recordings of findings will be conflicting on issues which not only substantially but directly in issue in LPC number 186, which are also on record in affidavit petitioner, without holding the matter any further, this court deems necessary that the petition be heard together by the division bench with so and so. The respective judgments lied upon this counsel and support the case is not discussed in view of this decision to place matter for the division bench. Let the records along this order be placed division bench for due consideration.
Refer to division bench. Also refer to division bench.
Division bench.
The interim order could have continued. The interim order could have continued till the matter is taken.
The issue is
still open to be. They'll be open to you.
Move the division bench for interim order.
With the difficulty, they'll render it infructuous.
There is your matter is pending. You can move before
we can't. Sustain interim order before the division bench. You are free to file the application there.
But till the division bench take comments, but your lordship is transferred the matter.
Your lordship, the issue is, my lord, that the matter is
since the inception there was a stay order.
Your lordship has held that the matter has to be heard by division bench. So only division bench is competent.
The matter it took some time very thoroughly.
Yeah.
And the thing is that the core of the entire petition is already in that affidavit filed for the division bench.
Well, the difficulty is the division bench matter is fixed on 7th. But the division bench matter is fixed on 7th, my lord.
He can
for the intervening period only, my lord, till the 7th. My lord.
Any mention?
Grateful.
Lordship, item number 20. After going through, I find that I should withdraw this application with the liberty to file again.
This Anuj Jain Bora, your lordship.
Why would you withdraw? I want to impose costs upon you.
There are some.
You see the kind of it's abuse of process of law.
That's why, Your
Civil
Lordship.
dispute has been dragged such an extent, and repeated adjournments have been taken. Where's that Mr. Bora who's appearing? Mr. from Guwahati?
They have all left.
Mehdi, I think.
Yes.
They have all left. And I took the brief, and on reading the brief,
Yes. There's more, yes. It's 20 on the London Senior Counsel, Mr. Vijay General, who has been engaged in a case, has submitted that on going through the matter,
there are some technical errors.
he may be allowed to withdraw the same.
With the liberty to.
Will you file afresh, so advise. The prayer is allowed. Matter stands withdrawn. Close withdrawal with liberty as prayed is. Yes.
No. Lordship, I beg to mention to move an unlisted matter today, my lord. There is an urgency, my lord.
What's the urgency?
It's, my lord, it's a society, my lord.
Eviction?
No, my lord, it's a society,
Demolition?
golf society, my lord.
Yes, sir?
Golf society, my lord. My affiliation to the Union Gulf, Indian Union Gulf Union, my lord, has been withdrawn, my lord.
Why?
Well, without any show cause notice.
No, what is the rate maintainable
My lord.
in societies?
My lord. It's a my lord, National Sports Federation, my lord.
So your affiliation has been, what's the urgency
Withdrawn.
you want to know? That's the only
My lord,
thing.
my lord, we have not been able to take any action, my lord, because there's national games, my lord.
When's national games?
That
Tomorrow. Why today?
there is some urgency, my lord. We are in the process of filing it, my lord.
No, golf means, what is the urgency? You satisfy the court that is urgency today itself, something's going to happen.
My lord,
What's going to happen today?
Lordship, there are some process, Lordship, because of the de-affiliation, Lordship, we are not being able to submit the forms and.
Last date today?
Lordship, yeah. Sir,
Last date today?
I've been informed that some of the papers works can't be done, Lordship, because of the de-affiliation. Lordship.
No, I mean the last date today.
Lordship, that is, I've been told. Lordship.
See, when the matter comes, we will allow it, but then if it's not as you plead, then
tomorrow, my lord, will fix it tomorrow.
tomorrow. Otherwise, golf is a question of demolition, eviction.
My lord.
Oh, yes. Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 19.
19. Who's for the petitioner?
I'm for the petitioner, Your Lordship.
You're for the petitioner?
Yes, Your Lordship.
What? Yes, what reason?
Your Lordship, Mr. Sen is unavailable.
What that matter?
Lordship, in this matter.
paper 6 day of 29th of May. We are 29th of May.
Okay, 29 of May. Yes. With the request of so.
Your Lordship, I beg to mention item number 41.
Number?
41, daily list. Your Lordship, I pray for 3 weeks time.
Yes.
I pray for 3 weeks time
Why 3 weeks time?
because the conducting council is indisposed.
She'll recover in 3 weeks. You're going to be sick for 3 weeks. Who's the conducting counsel? He's from Shillong. What's the matter about?
Your Lordship, I am being instructed to ask 3 week times.
No, who are you in the case?
No, Your Lordship.
None of the counsels are from Shillong. They are outstanding. Who instructed you?
My senior.
Who's the senior? Who's the senior?
Mr. Datta.
Who's Mr. Datta?
Mr. D.K. Datta.
Then he's not there in the case. What's your name?
Me?
Yes.
Poisalan Shilla.
See, your name's not here in the list of counsels also. Yes, what to do, Dr. Muzika? What's the matter about?
This is a discharge,
Made by?
discharge from Assam.
Raise made by your name?
P. Shilla.
Pishla. Who submits that? Who's sick?
The conducting counsel.
Who's the conducting counsel?
I'm being instructed to.
You don't know who's
ask
sick
three-
also?
Mr.
Who submits that? The conducting counsel, whose name is not known.
Mr. M.
is sick.
Thakuri.
M. Thakuri. Yes, in this post list after 2 weeks. Yes.
Thank you, Your Lordship.
Supplementary list, item number 2.
What is this?
My lord, this is an application for transfer of a
Any
session.
orders have come from Supreme Court?
No, my lord, the matter is still pending. And my lord, the other matters are also listed today, lordship, from item number 21, my lord. 21 to
List
20,
together, Mr.
27.
Third, Mr. N. Mansuri, issue notice. MSR Kolni is present, accept notice on behalf of
The state respondents, my lord.
respondent. Notice to go to the private response within 3 days. Yes, list together with the other connected matters
My lord.
on the next day.
Obligation.
Otherwise, we have to do something. We can't just keep it hanging like that. If not, the Supreme Court still, the matter is still pending.
My lord, yes.
But if interim orders are operating, then what should we do in the interim? We are left where this such spirit animation.
For the last order, my lord, the state is yet to file the affidavit. That's all.
Then we just left like that. Then what happened is some trials are stuck up, some trials are
My lord.
progressing.
Melvin,
Creates a lot of
that case of Melvin Solanki, my lord, it's alive now. After the stay,
Have it this matter after
it
2
might
weeks,
be
we'll
alive
see
now.
what happens.
My
Suppose
lord.
other orders come within two months, what will happen?
my lord, but stay has been granted. As far as it is not exactly clear,
It's not. That is why, Mr. Mansuri.
My lord.
That's why this court hands are tied.
my lord.
Item number 3.
Obligation.
Yes, Mr. Siddiqui.
Your Lordship, this is a contempt, Your Lordship, against the order passed by this court, which is in page 9, Your Lordship.
Against order by this court.
Yes, Your Lordship.
Violation or against order passed by this court?
No, violation, Your Lordship. Page number 9, Your Lordship. Where the state respondent, Your Lordship, has given an assure, Your Lordship, that for the salary of the prisoner will be paid, Your Lordship. But till date, no salary was paid. It remains only assurance, Your Lordship.
Who's appearing for the state? Last time, who appeared?
H. Kharwan Lang, Your Lordship.
Is here? No, doesn't matter. Heard Mr. Dinata issue notice, returnable in 2 weeks. Steps to be taken by the AD within 2 days, yes.
All right.
Item number 4.
Please, Lordship. This is a writ petition, Your Lordship, whereby the petitioner was the lingdo of Hima Soyong. Thereafter, Lordship, there was a certain complaint and allegation against me. Inquiry was initiated. Thereafter, my Lord, based on the recommendation of the inquiry officer, I was removed from the post, Lordship. But my only grievance and limited prayer, Lordship, is that the impugn orders at page number 23, Lordship.
You removed, but this is 19 June 24.
Yes, Lordship, but my only grievance, Lordship, is that I have not been furnished the inquiry report, Lordship, till date. I've submitted my representation letter.
Everybody you have removed since 19 June.
Yes,
When were you served with this order?
17 September, Lordship, that's at page 29.
So you got this order on 17 September.
Yes, Lordship.
And you waited September till now to come to court.
Lordship, we've preferred representation letters, Lordship, the last being on the 7th of November, that is at page 35, Lordship.
Yes, who's appearing for? You appeal
Your
counsel?
Lordship. Yes, Your Lordship. Your Lordship, I've taken instruction. We will furnish him the report as soon as possible, Your Lordship.
Lordship, it can be disposed of and limited time frame we given, Lordship.
When it is, where's the inquiry report? By whom?
It was conducted by the magistrate first class, Your Lordship. But then the report is for the executive committee.
Okay, that's been up. The report has been accepted by the committee.
Yes, Your Lordship.
So before the final action was taken,
I was never furnished,
you
Lordship.
never furnished the inquiry report.
As per what I've received instruction, no, Your Lordship.
Yes. And furnishing a report now,
Yes, Your Lordship.
whether it'll have, what effect will it have?
Your Lordship, it's up to the petitioner, Your Lordship.
To
What
exhaust my remedies because
remedies he
till
intends
date
to
I'm not
take.
aware of the decision making.
You're sure about that? Okay, yes. You want to close the matter?
Lordship, if the report may be furnished to me.
You'll close, the matter may be closed.
Yes, Lordship.
Heard Mr. Kharkarang, R. Kharkarang, the counsel of the petitioner. Mr. MS P.S. Nongri is present on behalf of all the respondents. As such, no further notice is called for. The grievance as or the writ petitioner is that when we suspended the petitioner, when we suspended?
Lordship, 2002.
Yes, 2002.
Yes, Lordship.
You never held office after 2002.
Your Lordship, but it was reinstated, but there was a pending inquiry, Lordship. The inquiry proceedings were going on for 2 years.
Then after that?
After that, the inquiry report was furnished to the EC. I was never informed about the report.
So that means from 2002 you firstly suspended and then you reinstated again after that?
Yes, Lordship.
Probably the petitioner before this court is the erstwhile Lingdo of So Yong. His grievance is that an inquiry which was instituted against him by the respondent number 30th committee, correct?
Yes, Lordship.
By the
Respondent number 2, Lordship.
HDC respondent number 2 has resulted in his being removed from, you took part in inquiry, but
yes, Lordship,
removed from office by order dated 19 June 2024, which was communicated to him on 19 September.
17 September.
17 September 2024. Stop. Next one, Mr. R. Kharkrang, Learned Counsel for the petitioner, submits that though the petitioner was allowed opportunity to participate in the proceedings, however, the impugned order has been passed without furnishing the inquiry report to him. He submits that the non-furnishing inquiry report has thus vitiated the entire process. Stop. MSPS Nombri, who was on behalf of respondent submitted that it is a fact that inquiry report was not furnished to the petitioner. She raised that as the grievance petitioner is only against the non-supply of the copy, the respondents are agreeable to furnish the copy within
1 week, Your Lordship.
Within 1 week to the petitioner. She further places that the matter is the prayers limited to this. As a prayer is limited, the matter may be closed up. Having heard that council parties and it is apparent, it is the undisputed fact is that the petitioner was never furnished a copy of the inquiry report, the basis on which his removal has been ordered. Stop. As the Regional Counsel for the respondent has undertaken to supply a copy within 1 week, the petition is therefore closed with the direction that
copies may be furnished to them.
Copy will be duly furnished as per undertaking. Matter stands closed and disposed of.
Item number 5.
Final blood, Lordship.
Yes.
Your Lordship, the writ petitioner is challenging the impugned order at Annexure 7, Your Lordship, page 27.
Yes.
The writ petitioner has been appointed as the authorised agent by the District Council to check the illegal trading by non-tribal commercial transport operators at Majai on 17th of January 2025. At Annexure 3 is the appointment. As per this appointment, Your Lordship, he has been authorised to be the authorised agent for the year 2025-2026 till 31st March 2026. However, by this impugned order at Annexure 7, his appointment has been revoked or recalled without giving him an opportunity, Lordship. So we are challenging this order.
Yes,
Well, generally what happened is these toll gates are settled in the month of March. Now your Lordship will see the page 21. This was done on 17th January. Now the present executive committee is trying to streamline all this.
It's 21st January of this year.
Yeah. Yes, my lord. 17th January 2025. My lord, even the 24-25 has not expired, yet the executive committee had renewed. Without issuing any tenders, nothing was done.
But nevertheless, I should have been given an opportunity. Your
And then there's no agreement also.
The copy of the
also has
agreement
not been signed.
Your Lordship, there is an agreement. There is an agreement signed. We have already asked for a copy, Your Lordship. We have already filed a representation.
We'll have after 1 week.
As per the records, my lord, the agreement has not been signed.
What is the records?
Records are here, my lord.
There is here. See,
agreement was
sometimes
prepared.
if no agreement was signed also, then there's no valid.
Even the earlier, my lord, 24-25 also, that agreement also was never signed.
We don't
by
have
the executive committee and.
So under what terms were you operating?
Only under this work order, Your Lordship.
It was prepared, my lord, but it was never signed. By them.
I operated under this order of 17 January, Your Lordship. We were under the impression that the agreement was already been signed. It was prepared, but I have to take instruction regarding that, whether it has been signed or not. We have asked for a copy of the agreement, but...
See, see, Mr. Sudran.
Yes, Your Lordship.
It's signed by the...
By the secretary. But he never came forward to sign also.
So you never agreed to the agreement?
Yes. It would appear so.
Then?
I have to take instruction from my...
I've heard Mr. R.K. Sindram, General Counsel, the petitioner, notice issue notice that the TTU Inside Council with so and so is present. We have all the respondents noted in this call for the grievance of the petitioner is that pursuant to this grievance is with the termination of the agency of the petitioner to at the page 27.
Page 27.
27.
Agency of the petitioner who had been appointed on 17 January 2025 for checking of checking of illegal trading by non-tribal commercial transport operators at Bajai East Castle district. They submitted that without any show cause and in spite of a valid agreement and arrived at between the parties, the respondents by the impugned order have arbitrarily terminated the said agency. Mr. Tirindo, let's say counsel appearing for the respondents has submitted that in fact there is no agreement in existence between the petitioner and the respondents and has produced a file which contains the record stamp. So Mr. R.K. Sindram on this submission of the Senior Counsel prays about how much time?
1 week time.
1 week time to obtain specific instructions. Just 1 week. Yeah.
Item number 6.
Well, the Government of Meghalaya issued notification for advertisement for the post of teaching staff of the upcoming Shillong Medical College, my lord, for the post of professors and assistant professors.
Where's the advertisement?
Page 16, my lord, advertisement.
At page?
16, my lord.
Rolling advertisement?
Yes, my lord.
Which post did he apply
There
for?
are about 20 petitioners had applied
20.
for dentistry.
This is the post of professor,
Dentistry.
associate professor.
Yes, my lord.
Dentistry.
Yes,
Okay.
but he
What
was not
happened?
found. he was not found eligible for that post because he had not been a teacher in any college. So it says that a professor should be minimum 4 years as a teacher.
Professor has to teach 4 years.
As an associate professor.
Yes.
But he had applied for associate professor. But because of that criteria, he did not fulfill. So he was asked that no interview can be taken, although he had applied for it. But at the same time, I thought the private respondent also, she also applied. And she also did not possess those qualifications. However, I don't know how interview was taken, and she was appointed as the associate professor, my lord.
She was appointed, she doesn't have the valid qualification.
No, my lord. Still she was appointed. And my lord, please come to page 23. It is the select list, my lord.
Dental?
Yes.
Yes.
And she was appointed.
Yes.
So here her name comes as associate professor, my lord.
You mean she doesn't have the qualification?
She doesn't have the qualification.
How, where do we find that?
Because at the time of interview it was found, I was said no interview can be taken. She was also informed that there is no such thing.
No candidate eligible, you mean to say?
Yes, my lord. And then again, my lord, on 18th March 2025, what Annexure 3, another notification comes from the government of Meghalaya.
Yes.
Here, my lord, she has been shown number 1 as selected for the post of assistant professor, my lord, again.
Where is that?
Page number 24. Number 1. Number 1 is the name of the candidate. Number 1, Dr. Arunavi, selected.
Yes. No, where's written assistant professor? Or on top?
On the top, yes, my lord.
So this post was never advertised?
Never advertised. Had it been advertised, then I would have also applied.
I'll require instruction, my lord.
How is it possible? If you advertise for associate professor, you select the person and then you appoint as assistant professor.
My lord, whether there was any subsequent advertisement, my lord, all
For
that
this
needs
department,
to be,
I'm sure there was no advertisement.
Need some clarification.
Senior Counsel, suggested by Mr. So for the petitioner, you should notice Mr. N. Sinkon, except we have 1 and 2, notice issue to the respondent number 3 within 3 days. Stop, Mr. N. Sinkon on submission to the Senior Counsel, especially on the fact that though the advertisement floated was a post of associate professor, but the parent respondents accommodated as assistant professor by notification dated 18 March 2025, prays that we will have to obtain instructions.
I have qualification for stay of this order.
I won't stay right now.
Let us get the instruction, my lord.
Yes. A list after 2 weeks.
Daily list item number 1.
In this case, the state respondent has already filed the affidavit.
Why?
There's ongoing admission in the college. So
which college?
Don Bosco University.
So the principal couldn't come to Shillong to sign the law.
Don Bosco College, Tura, madam. This is
So should we go to the college and get him to sign?
He couldn't come to sign the.
Where is the college base? He can't authorize it and send it to here. We want affidavit in 2 days. Otherwise, you see the last of the order sheet. How many times have you taken?
It will be the 4th time.
Yes. 17-2. You prayed for time. Then again allowed 4-3. Then after it's been filed in March by the respondents, by the state respondents, you put 1 week further time on 25th March. Now it's already May. Mr. Pasante, Learned Counsel 5 and 6 submits that the non-filing of affidavit has been caused due to the fact that the deponent for respondent 5 and 6 cannot come to Shillong. This is not accepted. Expected that the affidavit be on record by the after tomorrow. List after 1 week. Don't make excuses that he can't come to Shillong. It's a matter of the court. It takes precedence over everything else.
Item number 2.
Please, Malord, I'm praying for further time to file my affidavit.
Why?
Yeah, Malord, we're still waiting for some instructions.
What's the matter about?
With regard to boundary dispute, Your Lordship.
You are appearing for whom? Six?
For 6, Your Lordship, I want to make a formal prayer that I'm withdrawing as a counsel, Your Lordship. However,
Why?
I've informed because
Mr. Marpan also?
No, Your Lordship.
Then Mr. Marpan recorded number 6 last time.
My Lord.
Yes, Your Lordship. I'll be withdrawing, Your Lordship.
You'll be the counsel.
No, I'll be withdrawing as counsel for respondent number 6, Your Lordship.
You have wakalat.
Yes, Your Lordship.
You have wakalat again. Respondent.
Your Lordship, I also filed a caveat, Your Lordship, prior to them filing the writ petition. This was reflected in order dated 9
Let's see.
December.
Order dated
9 December 2024, Your Lordship.
9 December. But Mr. Marpan been appearing all along. That's why this court's inquiring. Oh, you appeared in 7th February last.
Yes, Your Lordship.
Mr. Marpan still be there.
Will be there.
Then
Your Lordship, respondent number 6 has informed me that by the next day they'll be ready with the affidavit. Your Lordship.
he'll be.
Ready with the affidavit. We'll take necessary steps.
Well, we will not record any name. We will just like MS number in behalf of S. Marpan. Submits the affidavit. We file the next date. Yes.
Malord, praying for 2 weeks' time.
Sangma also prays for 1 week's time.
2 weeks' time, Malord.
2 weeks' time for affidavit.
Your Lordship, continuation of the interim order.
Yes, it is also noted. It's also put on record that MSPS Nobri has withdrawn from. Withdrawn as counsel for respondent number 6. Yes. This interim order which will till next date. Yes.
Item number 3.
Well, in this matter, my lord, I am ready with my affidavit. Does the client need to come, my lord?
What affidavit?
Rejoinder, my lord. Rejoinder affidavit.
Why? Where's your client?
My client is in Garo Hills, my lord, and she is not keeping well. She is a very old lady, my lord.
How old is she?
Probably something around 65, something, 65, 67, my lord. It's old lady.
Within 1 week?
10 days maybe given.
Yes, Mr. S.A. pays for about 2 weeks time to file rejoinder. Just for hearing the after.
Yeah.
Item number 4.
My lord, item number 4, I've received the affidavit filed by the collector. However, the state union of and the NHITC are yet to file affidavit.
My lord, this affidavit is in respect of the legal objections, my lord. That
1 to 6.
Yeah, my lord.
By response 1 to 6.
Yes. So, my lord, the issue is that the decision of the has been challenged by way of writ petition, awarding compensation by various petitioners, my lord, and we have taken a legal objection as to the maintainability, my lord. So, if this issue is decided, my lord, then probably the writ may not survive.
My lord, they have an answer on the merits of the contention. In the affidavit, they have also answer on the merits of the case. My humble prayer, let the other respondents, if they prefer to file the affidavit, let them file.
No,
Otherwise,
see, we'll take his objection first, and then we'll decide if who are other respondents.
Answer 7 to 9.
Yes.
I'm going to find out.
No. See what happened by order dated 3rd of April. They are allowed to put objections by in the form affidavit, which they have done today.
Well,
what do you say? Why do you say?
my lord, in that case, the lordship gave me a 10 days time. I'll give a short reply to the objection.
Who are the most vital respondents, the state or center?
State, my lord, state. Because
Then we'll
State and Union of India, my lord.
Yeah?
State and Union of India, my lord. What happened in this case, my lord? The collector has fixed the award. Collector has fixed the award
Yes.
for compensation. Before the amount was released, there was a pressure perhaps from the high authority state government and Union of India to review and release the amount. So collector reviewed the award and released the amount less than the award fixed by him. So that is a limited grievance. That's the issue only.
Can you file affidavit before the next date? Or will take this matter for admission hearing?
Yes, we can.
Yes, an objection in the form affidavit will be filed by the respondents 1 to 6 pursuant to the order dated 7/3/4/2025. Stop. Mr. Chesareso submits that as many contentions have been raised. You want to file not the rejoinder? You want to file the rejoinder or no?
Lordship, other side also file a affidavit, my lord.
Okay,
Accordingly, I'll brief.
after 1 week for admission hearing. Stop. Dr. M. Muizka, paying for the respondents number 79, also praised you out to file affidavit. According to this matter for 2 weeks for affidavits of this matter for admission hearing. The affidavit should be on and for affidavit by respondents 79 years.
Well, the next item, affidavit not yet filed by any parties.
fine, my lord, because 4 we have raised the legal issue. Petitioners are the same, my lord. We will fill.
It's up to them.
We'll pass this order.
Yes.
Item number 6.
Deeply obliged.
Well, I've taken the instruction.
He's aware.
No, my lord, just what I was told, my lord, that he has given a statement before the police. Police has summoned him to give his statement in connection with the Lokayukt case. But subsequently, he has received the summon, my lord, to appear before the Lokayukt. Initially,
Close it now.
no, my lord, this is a different matter, my lord, altogether. Here, my complaint has not been addressed, my lord. It has nothing to do with the Lokayukt case, my lord. Lokayukt case is the opposite party, they have filed, my lord, against me.
And inquiry report already submitted, Mr.
Lordship, yes.
Mr. Sen. Mr. D. You've got a copy?
No, my lord, I have not.
Give him a copy.
Let him give us a copy, my lord. Let a copy be furnished to me, my lord, and let it come up next week, my lord. I can.
But then did you appear Lokayukta or not? Because this, as per inquiry report, see,
my lord.
You filed a complaint,
my lord,
under Section 20 of the Lokayukta Act. Okay. Yes. Now you are the 5th complainant. VEC Chairman of Village, Nongdam Nongladao.
No, I'm a respondent there, my lord. If they can furnish me a copy, my lord, I can at least assess this honorable court in. I'm not aware, my lord, whether I am petitioner or respondent, my lord. As per my instruction, my lord, I am the respondent, my lord.
Oh yes.
Lordship, he is the offset party, your lordship.
Yes. Number 5.
Yes, my lord.
Now he will stand as an accused, your lordship, if a criminal case is registered against
Now
him.
Inquiry is yes. What do you want the petition?
My grievances was this, my lord. We have lodged a complaint before the DC, my lord. My complaint has not been addressed.
But this Lokayukta report is quite detailed.
But that has nothing to do with my complaint, my lord.
It's not to do with MG and RGA.
No, it is a different project altogether, my lord. Different project, my lord. Why do you feel shy, my lord, to supply me a copy of the inquiry report? So,
there is no question of feeling shy, your lordship.
So let them give us a copy, my lord. I will be in a position to assist this honorable court.
One thing, Mr. Day, you also filed a complaint against the Ursula headman.
Yes,
that
my
means on 7th of July 23 and also on August 23.
Yes,
correct?
Yes, my lord.
Yes, it will be recorded. Now out here, you see. Now there are some, we'll not say it here, but there's some finding against you.
My lord, there may be a finding, or I am not aware, my lord, of what is the finding against
all
me.
these proceedings are interconnected for Lokayukta. What purpose will it be served by,
Because
maintaining the petition before the court?
my allegation before the DC was this, my lord. A project was sanctioned, my lord, for the village. That project was never they have never utilized the project, my lord, or they have not even executed the work of the project, my lord. They have just taken out the money and they have eaten up, my lord.
Lordship, kindly come to page 7 of that report, Your Lordship. They were aware, Your Lordship. He is aware, Your Lordship. He has concealed this fact before this Honorable Court. Lordship, kindly come to internal page 7 of the report of the inquiry. In order to find out the person involved in forging the signature of the complainant, the BEC chairman, that means the writ petitioner, was thoroughly examined, as well as the BEC secretaries, who on the statement claimed that they have organized a general meeting on foot. And they are aware, Your Lordship. They are aware, they are very much aware, Your Lordship.
And even the,
but this fact was never stated, Your Lordship, before in the writ petition.
If you want to go to petition, fine. But if we find that it is, there's some.
My lord, only my grievances. My grievances, my lord, may kindly see, my lord. I am before this honourable court, my lord, for non-disposal of my representation. My representation, my lord, whether it is a correct representation or not, DC has to decide, my lord. DC cannot sit over it.
If there's a larger inquiry under the before Lokayukta.
But there is a two different project.
No. Whatever it is, this all the things. This is your you agreed that this is your complaint. Also, you file your respondent another complaint. All is been taken together. This is a report.
There is not a violation of two complaints, my lord. They are conducting an inquiry on the.
A copy of the
Lordship, yes. We'll keep.
Let's come up next week, my lord.
Is the learned counsel, the petitioner submits that submits instructions that you are aware of the proceedings.
I was not aware of the Lokayukt. I was summoned, my lord, by the police.
How can you give his
my lord.
Then the
Can
investigation.
My lord, yes? Kindly appreciate, my lord. Lokayukt never issue notice in the instant case, my lord. First, they have. It is the police.
The proceedings, not aware.
Subsequently, I came to know, my lord, after I give my statement, my lord.
That the writ petitioner subsequently came to aware about the proceeding stop before the Meghalaya Lokayukta. On the last date, the London AAG had furnished a copy of an inquiry report on the proceedings before the Lokayukta, wherein the name of the writ petitioner figures prominently. Mr. SD, however, has maintained that the proceedings with Lokayukta is in connection with a different set of complaints and is not related to the subject matter in instant petition. Be that as it may, that a copy of the inquiry report be furnished to the petitioner. This is the matter for further orders after 2 weeks. Yes.
Apply, Your Lordship.
Item number 7.
Lordship, a notice on the respondent number 1 could not be affected, Lordship.
Could it be affected?
Yes, Lordship.
Why?
Because as per the remarks, it is saying that
you give the wrong
AGC has left the office.
Who has left?
AGC. So it seems the AGC may have transferred.
Who's the AGC here?
The Commissioner, Lordship, the Commissioner of Custom.
This contract regarding gold bangle?
Lordship, yes, sir, Lordship.
Yes, Dr. Musika, you return the bangle to Mr. Deb.
Not.
You're not aware. You are appearing in before the division bench, correct? This matter is there or no?
Disposed of.
Return the bangle.
Not yet. Not yet. They have not returned.
Then who's the Commissioner of Customs now?
So it seems that someone new came, Lordship. New commissioner came. So if it's so, Lordship, I may be allowed to take steps, and if it's necessary, so I may be allowed to amend the cost structure also, Lordship.
Upon the respondent 1 and 2, due to the fact as it appears that they have since left their present place of posting. He prays for allowed to obtain the correct identity and the receipt of the contemners to be substituted in a contempt application.
Lordship.
Yes.
Lordship, if it is possible, I may be necessary. If it is necessary, then I may be allowed to amend the cost title also, Lordship.
Of course. Get the names first, we file an application.
All right, Lordship. All right.
That is the manner in which is done.
All right.
Item number 8.
Please, Lordship,
As for the track consentment, the private respondent notice has been affected. We may be allowed to just file a affidavit in service.
Yes, affidavit file.
On record.
My lord, I am still awaiting instructions.
When is the matter filed?
This matter filed this year.
Yes, Mr. P.T. Samas prays he will have to file an affidavit indicating his responsible for 5 stop. Mr. Kiva Rasaji on behalf of 1, 2, 3. Basa. And he will pray for another further 2 weeks time to file affidavit. Just thereafter and so.
Lordship. Much blessed, Lordship.
Item number 9.
May it please your Lordship. Your Lordship, the state respondent may be allowed some more time to file an affidavit.
What's the matter about?
This is regarding regularization with retrospective effect. 66.
Which department?
They are paramedic.
Health Department.
Health Department. On the already 3 weeks time last time.
Yes, your Lordship.
On a prayer of the so for the 2 weeks time granted for affidavit. Just thereafter and so.
10.
May it please your Lordship. Your Lordship, we are waiting for the status report. We are waiting for the status report, your Lordship.
What's this report?
Status report on the respondent, your Lordship.
Receive back. They already received notice.
Yes.
Officer indicates that you're for the Nehu.
Nehu, your Lordship.
Has been duly served upon the sole respondent. However, there's no representation today, just after 1 week. Just after 2 weeks.
11.
Same, your Lordship.
They've been served also? Certainly. Officer indicates that service study is complete on the sole respondent. MSE blood obtained status of service.
I do oblige, your Lordship.
12.
May I please, your Lordship?
Yes.
Your Lordship, some more time may be allowed to file the counter affidavit.
Pension matter, your Lordship. Pension
matter?
Yes, your Lordship.
How long have you taken? When does it file?
Your Lordship, this
when
is
does
the
the person retire?
last year 2023, 2023, your Lordship.
Working as?
Lab technician, your Lordship.
Lab technician?
Yes, your Lordship.
File within 1 week.
2 weeks, your Lordship, final.
How many times you've taken?
This is the second time because after
Mr. Kaji Puri has gone out further 2 weeks time to file. Yes, after 2 weeks. Yes.
much appreciated.
13.
May it please your Lordship. Your Lordship, I am for respondent 1 to 4. Your Lordship, in
Yes.
this matter, I paid for 3 weeks' time to file the affidavit.
This is what matter?
Demarcation, Your Lordship. Demarcation.
Demarcation. You too. ठीक है. Number. You're appearing for 7 also?
7.
Yes, MS Emmer Haman has done appearance today on behalf of the respondents 5, 6, and 7. As such, service is complete. Stop. MS Lalu, correct?
Idakhar.
Oh, sorry. MS Idakhar for 1 to 5. Ms. SD 1 to 4. Prays for around 2 weeks' time to file affidavit. Similar prayer. Similarly, response has allowed 2 weeks. Yes, list after 2 weeks. Yes.
14. Obliged, Lordship. Similar prayer, Your Lordship.
Yes.
Similar prayer in this matter.
Prayer for
3 weeks.
He has a prayer for interim stay. Where's Mr. D? You call him. We take it after some time. Okay. You are appearing for whom?
Yes, for private respondent, my lord, for number 485. Interim appearance.
You ready with the matter for interim prayer today?
No, Lordship, I need to prepare. Give it. I just got yesterday only the notice.
Yes, Mr.
Your Lordship, I respectfully submit, Your Lordship. They are not allowing us to enter in our own land, Your Lordship.
Your Lordship, what I may submit as per the instruction, Lordship. This case is still pending with the CEM of justice at present, and then there is an order also from the CEM.
Okay, we'll do one thing. We'll fix it on Monday.
Your Lordship,
Since they just entered appearances.
Lordship.
We met the disposal of Mr. P.T. Sharma as an appearance today on behalf of the respondents 4 and 5. And as such, 5 and praise it below. How much? 1 week's time to file.
1 week's time, Lordship.
Top. Next paragraph. It is noted that an order dated 16/4/2025. The learned counsel for the petitioner has prayed for interim orders, and the matter has been fixed, accordingly been fixed today for hearing for considered interim prayer. Stop as Ms. Nikla has made for his appearance for the end of justice list after 1 week.
Your Lordship.
Interim prayer. You be ready.
Your Lordship, I would like to submit one notification, Your Lordship.
Not now.
15.
Lordship, as per your Lordship's last order, we have already filed the affidavit to bring on record the Constitution of the Meghalaya State Counselling Authority.
Yes.
But the Constitution was done only for the year 24-25, your Lordship.
And this
And there was no...
These admitted when? They admitted...
23-24 for this...
So what will be the fear of the students then?
That I think the NCISM can also see. So we may be allowed to file a detailed affidavit, your Lordship,
No,
because on the last affidavit we only brought on record the Constitution of the Counselling Authority.
And the new batch has already started the counselling.
The new batch has already started counselling.
Your Lordship, what happened is actually we have been pursuing either with the state counselling authority that prior to the taking counselling, we have approached that we have admitted some student to for taking counselling. Then once they also have received, once they received our approach, they have informed that that they don't have the counselling center in the.
So that's exactly what the wants to know. Yes. In the absence of such an accredited counselling center in the state, how are the students admitted?
No problem is Lordship. Actually, it is not on our part.
Can it be corrected retrospectively, Dr. Mosika?
Yes.
What I understand, my lord, is the integrated system of admission, my lord, through the counselling. They, without any consent from
they find are not admitted these students, whatever. Can it be corrected retrospectively? Can the defect be cured, or it's incurable? Incurable.
But one thing is Lordship, the Lordship, university is very much aware. We have been pursuing either to the.
No. Pursuing the sense that fine. Then why did you admit the students if there was no state counselling authority and you could not get the the sanction of what's this? NICE. What is your respondent number?
Respondent number 5.
Yeah.
Let me give this.
It's called Indian System of Medicine.
We were given only 18 days time, and then we have approached both the state counselling and as well
as.
There's
no state counselling.
Yes.
The file showing that only in 24-25. Now your admission is done 23. You have admitted, how many students you admitted?
36.
What happened to them now?
Now regular class is going.
No, what happened to them when they graduate? They've been, defect. The whole admission, the admission is defective. Can it be awarded a degree? Then they'll become like this Kabiraj on the street after getting a degree. Then?
Your Lordship, what happened is actually...
No question what happened. The thing is very simple. There's the set procedure for how you can admit the students after counseling, so on and so forth, and to get the sanction of the National Commission in System of Medicine. Correct?
Lordship.
Now, there was no state counseling agency. But then, on your own, which you could not have done, you admitted the students. That is 23. Now, how many years of the course?
No, Lordship, what happened? Earlier, they have informed that only the or Indian quota, that reservation should be done by the the counselling should be done only by the state counselling or by the national this one. So later on, only after taking admission,
you didn't do it. You did yourself.
Later on, when we have taken the admission, only they have informed that all, irrespective of all the student has to be taken to. That was informed only after later, and
yeah,
they.
How many years the course?
It is a 3 years course, I think. 2 years. 1 year. The course is.
The admission is supposed to be on the basis of all India rank, my lord, in the NEET. What they do, my lord, they don't refer to that, they take admission directly.
No, that is not correct. Actually, we have approached them. There is no communication. They have not responded to our plea, because there are a number of representation. The communication that we have make it. It is not that. And finally, they have constituted the hearing committee. And regarding this admission, we have appeared in the hearing committee. They have asked us to submit all the documents, all the relevant documents, whatever we have submitted, and we physically appear. After that, there was no order as such from the hearing committee. Then later on, without passing any order, they have just rejected our student.
See, you see page 14, paragraph 4, Roman 4 of your petition. Read it.
The Competent Authority of the University of Technology, Meghalaya, framed the counselling committee for admission of the management quota seat. Observe the eligibility criteria for BAMS.
So you form your own counselling committee.
Yes, Lordship.
Previous month, they were management quota, they must have taken some good capitation fees and given admission. They should disclose also how much capitation fee they have taken.
That we.
How much money have taken for each student?
That I am not have no instruction. Lordship, to that effect, I can file it.
No need.
I can verbally. I just need to get the instruction.
Stop.
Otherwise, my lord, there is a judgment also where the university have their own have the right to. I will place it on that time of hearing.
It is a private university.
Not even a private. This one is there, Lordship.
Yes, an affidavit containing the constitution of the Meghalaya State Counseling Authority has been filed by the state.
5 and 6, Your Lordship.
Parcel 5 and 6 stuff. The same is perused and is seen that the counseling authority has been constituted for the year 24-25,
Your Lordship.
whereas admissions of the concerned students by the petitioner university were done in the year 2023 stuff. It has been submitted. It's also been submitted by Dr. Mbozika, Reliance Council 1 to 4, that the admission process which has been undertaken by the petitioner university is defective. He prays him out to file an affidavit within 3 weeks' time. Similar prayers also made by the MST Yangi prayers allowed. Yes, also 3 weeks.
Yes, received affidavit. Question 16.
Most please, Lordship.
What do you mean by Sahab? Yes, Dr. Mozika.
Well, same, Your Lordship's judgment, page judgment dated 17/2/2025, passed in 418 of 2024. They are left out employees and page 272 and the relevant page 277. Your Lordship's order. They are left out, and on the other occasion, Your Lordship passed the order. To extend the benefit, redesignation, upgradation cannot be treated as a promotion.
What instructions do you want to receive?
What instructions have not come, my lord. I am praying for a week's time, my lord.
My lord, para 2, page 277, Your Lordship. Exactly same, of the same trade, my lord.
It appears, my lord, is but just 1 week's time, my lord.
Is there any difference? The only thing, the concern of the court is that if you agree that it is the same, that...
that has been implemented. I have included the implementation order also, my lord.
The last chance.
What a factual part, my lord, if there is any difference.
Because let him just...
So 1 week's time.
Service. Though it is submitted that the incident matter is clearly covered by the judgment of the court, and the same has also been for the court stop. Dr. Mozika expresses his helplessness due to the absence of proper instructions. He prays not 1 week's further time as last chance. Prayers allowed just after 1 week. Yes. We'll dispose it of next week.
17.
Lordship, I may be given another 3 weeks time to file my counter, Your Lordship.
What's the matter about?
It's a job for in lieu of the land taken by the PWD department.
Without our consent, Lordship.
Mr. Engineer, please for a further 2 weeks time for affidavit. Right?
Hello, Bledge.
18.
Yes, Dr. Mozika, what's the matter about?
Your Lordship, this is first time I'm appearing on this case, so I'm following the instruction of conducting counsel is from Delhi. I don't know this matter about. I'm just assisting.
Why are you appearing? You don't know the case.
I'm assisting Your Honor because Your Lordship because the conductor counsel is from New Delhi. So
what can we do about it? You're standing here. You're representing the petitioner.
The petitioner in the recruitment rally of Assam Rifle was selected for a post of Havaldar clerk, my lord. Now, in subsequent verification of document, it was found that there is a pending criminal case against him under the Atrocities Act, my lord, SC and ST Atrocities Act in Maharashtra. And because of that, his candidature was cancelled. Against that, he has come, my lord. But the latest instruction is that the criminal case is still pending, my lord.
Yes, Dr. Mozika today on instruction submitted that the petitioner was not considered further for selection in view of the fact that there's a criminal case pending against him under the Scheduled Caste Scheduled Tribes, what's it called?
Prevention of Atrocities
Act of 19. And you will get it, yes.
I'll check it.
3 weeks for affidavits. Yes.
Hearing 21.
But this is a transfer matter.
Courts also feeling a bit, because we can't leave it hanging like this also.
Exactly. Therefore, we thought of praying, my Lord, to hear the matter. Otherwise, it cannot continue to go on like this.
Let us just hold it for 4 more weeks and we'll see.
Yes.
Yes, as the matter is still pending consideration before the Supreme Court. So interim orders are operating. Awaiting outcome this batch of matters after 4 weeks.
Yes. Deeply obliged.
28.
May I please, Your Lordship? These are all connected VC matters, my lord.
How many matters are there?
9 matters, my lord.
Today they are listed. Very good. Start.
My lord, yes, my lord. 26 to 28, my lord.
Yes.
28 to 36, my lord. Sorry, my lord.
20?
28, item 28 to 36, my lord.
You are ready, Mr. Guru?
My lord, yes.
My lord, this matter
with only to the limited issue, my lord, with regard to the direction to the BDO concerned to the conduct elections, my lord. Since the terms of the concerned VCs, all the 9 VCs had expired for long time.
All Cecilla.
My lord, yes, my lord, under Cecilla, my lord. Under Cecilla, my lord. Item 28, first item, my lord. First item. Yes, my lord. The terms, my lord, were the item 28, my lord. It's my lord, Fechakandi VC, my lord. Yes, my lord.
You mean to say that even after Infrastructure Regulatory Commissioner, the BDO was not holding elections?
No, my lord.
In all the matters?
All the matters, my lord.
I am 28. Or 28, this item 28. Yes.
My lord, yes, my lord, 28. These are all connected matters, my lord.
Mr. Guru, yes.
My lord, here what has happened, my lord? I have filed my affidavit, my lord. My lord, we are well aware of the fact that it's in Jurul Islam. What is item number? Item 36, we have filed affidavit. We are relying on rest of the.
Let's see affidavit.
My lord, will come to page 2, paragraph 6, my lord, onward. If I may read, my lord.
Yes.
That in reply to the averments made in paragraph so and so of the writ petition, the answering deponent submits that provisions of Manrega Act as stated in the petition are duly acknowledged and all the necessary steps have been taken to implement the scheme in the village at Patranga. The answering deponent admits that VEC elections are required to be held every 3 years and recognizes the delay in conducting this election due to the logistical and administrative challenges including bifurcation of blocks and shifting of VECs to newly created blocks. Approximately 71 VECs including Patranga are required to be shifted to the newly created Batabari CNRD block. The answering deponent is prioritizing the clearance of pending liabilities such as wages and materials payment to ensure a smooth.
Give a plain, simple answer. How much time do you require?
My lord, that state responded
My lord,
to BDO concern.
How much time?
My lord, on war footing we are doing this shifting, my lord. So, my lord, let this matter come after 2 months, my lord. We will try to complete that, my lord.
No, we'll give past direction. You finish within 2 months. Otherwise,
my lord.
Contempt issue.
My lord.
We can give past a common order.
My lord, let it fix after proper instruction whether they shifted some, because I have also received
some has been done, my lord.
Because last occasion senior has
conditional order.
My lord, yes.
In areas where the shifting has been done,
my lord,
it should be held immediately elections.
My lord, that apart, my lord.
And in areas where the bifurcation or shifting is yet to be effected totally on the ground, then we'll give it 2 months.
That apart, my lord, the pending areas of my lord, payment and all, my lord, that has to be done. It's not only about shifting, my lord, per se.
But that's your duty under the Act.
Exactly, my lord.
Then the people have to get the job cards, they have to be paid.
Exactly, my lord. But this is.
We can't say that just because they're shifting, bifurcating.
My lord, because of this issue, in most of the.
My lord, yes. My lord, I have enclosed the notifications, my lord, from the government, my lord. So I have to, my lord. I have to abide by that, my lord.
See, this is
Kindly come to Annex 1, my lord, page 8.
This is Cesara in RD block. So 9 in RD blocks. In 9, there are 9 newly created in RD blocks.
And 71 villages has to be, my lord, shifted, my lord. And this shifting is not, my lord, shifting simply shifted, my lord. It has to be, my lord, payment of all the pending dues, those sort of things has to
but
be.
You see your letter dated when?
My lord.
2 years. Nearly 2 years.
Yes. 8
So,
June
lord,
2023.
A common order may be passed, my lord. I may given 2 months time, my lord.
Yes. the common prayer in all these writ petitions is with the
cases are only this, no? This all cases are for this, no?
No, it's 9
so expired when in item 28 when
my lord, different dates, my lord. Some are in
28 when
28.
Item 28.
Aziel Hawk, yes, my lord. Aziel Hawk, my lord, is expired on 5/11/2021, my lord.
Which one? 21.
Oh, my lord, sorry, my lord. My apology, my lord.
Number one.
The Aziel Hawk, my lord, it's expired on 12/2/2024, my lord. It's item 28, my lord.
28. Aziel Hawk. Where is
the common prayer
12/2/2024.
in all
yes,
in all the batch petitions is with the non-holding of elections to the respective village employment councils as mandated by the Act and rules. Act and rules stop. The petitioners, it is submitted by the counsel of the petitioner that in the said VECs, which all fall under Celsela.
Yes, my lord.
This is new created CRT block.
No, my lord. Celsela is old, my lord.
Yes.
Old. Now newly created at Batabari, my lord.
C and RT block, West Garo Hills, for the reasons that bifurcation or relocation of villages has been affected on creation of new CRD blocks.
Right.
The matter has been delayed. However, it is submitted that the delay, the prolonged delay, is affecting the day-to-day life. The whole prolonged delay is inexcusable in as much as far back as in 2023, or there's orders from the state respondent itself that that the bifurcation from the existing blocks we be completed at the earliest. Stop. It is submitted that the writ petition has been compelled to approach this court in view of the inaction of the state respondent in this regard. Stop. Ms. R. Gurung, Leonard Counsel, the government advocate appearing for the respondents, has not denied that the situation is not as stated by the writ petitioner. He only submits that in view of the fact that there are 9 newly created CRD blocks which have been bifurcated from existing blocks, time is required for shifting from the parent block to the new blocks of certain villages, and that this involves the clearing of pending liabilities such as wages, semi-skilled and semi-skilled, materials, physical completion of all ongoing works, and also geotagging of pending assets. He submits that the delay has not been caused deliberately, but by the fact that the process requires time. In this connection, the counsel referred to a letter dated a communication dated 8 June 2023, next section 1 to the affidavit. The we phrase that the citizens be allowed 2 months' time to complete the process and to conduct elections.
Right.
I've heard the counsel of the parties as submitted by the petitioner. It is seen that prayer is limited only to the reconstitution of the VECs by way of fresh election as mandated by the Act and rules. Stop. A perusal of the communication referred to by the learned government advocate dated 8 June 20 by the learned government advocate shows that the communication had been issued as far back as on 8/6/2023, and the direction contained therein is that the above activities was to be completed on a priority basis for all the affected VECs. Stop. In his view, the matter, as much time has passed since the issuance of that letter, this court directs that for those villages for which bifurcation and other formalities have been completed, the concerned respondent shall conduct elections as expeditiously as possible.
Right.
And for the other villages for which the prerequisites have not been completed, 2 months' time is allowed.
Right.
Next part is ordered accordingly. And
it is more after 2 months election should be conducted.
Yes. It's already there in the order.
My lord, I'll file my.
It is expected that the respondents shall comply.
My lord.
Faithfully with these orders. Yes.
Deeply obliged.
Well, highly obliged.
37.
Yes.
My lord, we are also asking for a similar order, Your Lordship. That is, last judgment, the implementation order I have enclosed. They are asking for warrant officer. They are left out, my lord. 10 persons. In the two root petitions are common, item 37 and 38. In first case, my lord, 7 persons, and in second case, item 3 read petitioners. So, my lord, last judgment passed by this honorable court, page 195, Your Lordship. Page 195.
1 second. Page
195, my lord. It is started from 195 and operative part of the judgment, page 212.
You mean to say till now, till date, some people still left out?
Left out, my lord. Left out.
In the forces?
My lord.
My lord, I have two submissions to make, my lord. One of the order which they are saying they are squarely covered with, my lord, this is page 195. This is an appeal before the division bench, my lord. And your lordship and the honorable chief justice heard the matter, my lord. But it's not concluded, my lord. On several, it was listed a number of times, my lord. The matter was heard before the bench, division bench.
My lord.
So this has not attained finality, my lord.
No, finality, it has attained finality. Lordship will find. I have enclosed so many implementation order. Lordship may look into page from
let Dr. Moses.
Warrant officer from Arkanayar, my lord. Arkanayar's case, first case was Arkanayar. And they, after Arkanayar, Digambar Dutt, all these cases have been implemented, and I have enclosed all the implementation orders. I have enclosed. There is nothing to be, my lord, this has already been settled. And this judgment also very detailed judgment. After putting all the implementation order, this judgment have been passed. It is from very long judgment, my lord, taking everything in consideration.
Let Dr. Moses complete. Yes.
My lord, there are 18 technical traits, my lord. Your lordship are aware 10/10/97 notification, which talks about 3 cadres, my lord, draftsman and radio mechanic. Those 3 cadres were to be given warrant officer. There is no dispute about that, my lord. The OM itself says that those 3, because of their higher entry level qualification, my lord, they will be entitled to that. So there are several cases, orders passed by this honorable court, my lord, pertaining to those 3, those we have implemented, my lord. Now they cannot seek parity because here the petitioners are storekeepers, my lord.
See, Dr. Mozika,
My lord.
just to remind you all that there was no direction, yes, under the memorandum notification, but you had extended by yourself to other trades.
But
so if once you extend yourself by other trades and you worked out the financial implications, how can you deny the other people?
No, my lord, there's a slight difference, my lord.
What's the difference?
My lord, as I submitted, there are 18 technical trades, my lord. 3 were given special treatment, my lord. The remaining 15 were to be given Havaldar, as per what we understand. So 3 have been given draftsmen, my lord. They, at the best, they are entitled to Havaldar, my lord. No, not, can I just... But the learned single judge in identical matters, my lord, the other court, my lord, has given them warrant officer, which we have challenged, and it is our case before the division bench that warrant officer entitlement is only to those 3 categories, my lord.
These argument in all the cases, my lord. All the cases similar argument, and Mr. Mujaika has done.
No, how can you differentiate storekeepers from the other trades?
Because the OM 1097 itself says, my lord.
No, fine. OM 997 is where it
all emanates, my
genesis of all problems.
Now that says that
you have been saddled with. The thing is that now across the board you've given them that
across the board we have given, my lord.
Yes,
3 have been given warrant officer. Operator radio line have been given Havaldar, my lord, against which they filed a contempt. They are also asking for warrant officer, my lord. Because warrant officer is a rank higher than the Havaldar, my lord. Now again the storekeepers have come. Storekeepers, the learned single judge by page 195, my lord, has granted them warrant officer directly, my lord.
One is the storekeepers. And the petitioners here are whom?
Storekeepers.
Storekeeper.
That is when given, then we have to maintain judicial discipline.
My lord, page 212, my lord, kindly, if I may refer to, my lord.
And my lord,
yes.
Page, the direction given on para 38. This being the case, the respondent authorities are directed to issue appropriate orders and directions to bring parity in respect to pay scale and rank structure of riflemen, SKT means storekeepers, my lord, as well as Havaldar SKT in the Assam Rifle at par with other central police organizations by introducing the rank of warrant officer, assistant sub-inspector at the entry grade from the date of remusteration, so as on having completed the training course.
Same order have been passed in other cases.
Can I just...
Yes.
From the entry grade, the learned single judge has granted them warrant officer, my lord. Our case before the division bench is there are only 3. At best they are entitled to Havaldar, not warrant officer, my lord, and that is pending before. Now if they claim, my lord, they are covered by this judgment, not by the other judgments of draftsmen which they were next, my lord. So those will not apply to them, my lord.
Well, I'll show the implementation order. Riflemen also given their implementation orders. Their implementation order I will show, my lord, page 51. Even riflemen also given warrant officer. Their implementation order, lordship will find page 53. And all these cases, even Cypher, they are having matriculation only. We are diploma holder. We have been sent for training, and 2 years diploma also we have taken. We are better qualified. Even Havildar Cypher also given. They are only matriculate. And now, my lord, lordship will find page 53. The rifleman draftsman also given. Lordship will find serial number I. Page order dated.
No, what's the status of the division bench matter?
And my lord, pharmacist also I have enclosed. Pharmacist I have enclosed. Then my lord.
Mr. Chanda, we understand. We're just trying to understand what difference does Dr. Muzika seek, whether he can satisfy the court that there is that qualitative and qualitative difference.
My lord.
That the only argument is that you're not seeking parity on the basis of the other judgments. On this judgment only.
On this
judgment. This covers storekeepers. How can we decide otherwise?
My lord.
Then?
So, my lord, either since the matter is before the division bench and your lordship is a part of the bench, my lord. That's one
argument. Are you the division bench matter before the single bench now?
My lord, I'm not arguing.
You have to limit the arguments to what's here before this is good.
I'm only submitting that, my lord, because it is pending before the division. This is not attained finality.
Similar order, my lord.
This is not attained finality.
Similar order may be passed.
Because the other matter will become handicapped, my lord.
No, my lord. Actually covered by all the judgment, and all the trade got it. All the trade got it. Even having matriculation.
Mr. Chanda, all the trades got it. Just by their own feeling only, not because of any court order. When they extended that, then they fell into the trap. How many petitions here? Only 9 petitions are here.
9, my lord. 9, and in the other case 3 petitioners. 12.
My concern
They are left
only is that, my lord, we lordship dispose of this matter, my lord. The division bench matter, my lord, which is in sum and substance same matter, my lord.
Exactly. Now, this coordinate bench, in a single bench, has allowed their prayer.
My lord.
They are the left out people sitting the fence.
My lord.
Correct.
But this is not a 10th penalty, it is on appeal, my lord. It is pending before the
Fine,
division
on
bench.
appeal, but then you can't make arguments of appellate arguments now before single bench.
I'm not making that argument, my lord.
Yeah, but it is argument saying that is the appeal is that we're saying that there's differently situated
Yeah,
with
my
other
lord,
trades.
I'm only making argument to the extent, my lord, that the claim
Be kept in abeyance.
kept in abeyance till the matter is decided by the division bench. Or if lordship dispose, we will have to file appeal.
They can file the appeal, my lord.
Because where is that?
My humble submission, my lord, lordship may pass the same order. Let them go to appeal, my lord.
The difficulty that connected is appeal is before the bench of a lordship, my lord, in the division bench.
That will make no
That
difference.
is a consideration.
That will, because your lordship also clarified it in a separate judgment. Upgradation is not a that your lordship judgment.
That is no
I have
bearing.
brought also. I have
That is
brought
no-
also.
that is no bearing.
Your lordship also made it clarified, and they should be given the benefit of SEP. That is the judgment. Your lordship judgment. Your lordship judgment. Lordship Devdrai, 89 of 2019. Your lordship already clarified it.
So even a division bench judgment that Justice Sanjay, that judgment says like.
And Mahesh Kumar case
My
also.
lord, in those matters, Mahesh Kumar, which are pending before Supreme Court, what has been granted is Havaldar, my lord, not the warrant officer. Here,
The illustration also Havaldar.
my lord. So here, this honorable court, the learned single just gone one step beyond, my lord.
No, but one consideration is that I'm in the other bench in appeal.
My lord, it will not make any difference, my lord. It will not make any difference. It is a covered case. My lord.
After 2 weeks.
If the matters are clubbed together, my lord.
My lord.
We send a division bench as a matter.
My lord, that can be one, my lord.
Yes.
Lordship may observe that because that is an identical matter. In the
So
place.
many they have implemented.
I mean, we send a division bench with outcome of the matter division bench. We send this matter together there also. But they've been granted the benefits. They have not got anything. That's the only problem.
Then let
And
it be
in
there
these-
after
in
2
these
weeks.
cases, frankly, Dr. Moses has nothing left to decide also.
My lord, this one aspect is left to decide, my lord. Whether all will be warrant officer or only 3 will be warrant officer.
Their decision he has argued all along, my lord. Last 10 years he is arguing this. 5 to 10 years.
No, well, we are fighting that
5
they are
to
not.
10 years he is arguing
They are not
same,
even entitled
same
to,
contention.
They are
my
not
lord.
even entitled to Havaldar. That is the line of argument which we have taken. My
That-
lord. That is pending before the
Three
Supreme Court.
category, these argument and all these cases have been implemented. They tested the matters before the Supreme Court also. They have tested the matter Supreme Court also. Arkanar case they have tested. My lord, this Digambar Dutt they have tested.
My lord, that
The
OM is just the
Rupinder
next
Singh
page,
they
my
have
lord.
tested.
That office memorandum is just the next page after the judgment, page 213, my lord. Any reading of this notification cannot mean, my lord, that everybody is
No,
entitled.
these argument he is making for last 5 to 10 years.
Well, warrant officer has not been given to all, my lord.
These argument, then how they have implemented this? These are implementation order I have enclosed.
Havaldar has been given to all, my lord, I admit that. But warrant officer has not been given to all, my lord.
Yes.
This is the 22nd January 98.
My lord, I have shown even rifleman is given a warrant officer. Rifleman is also given a warrant officer. Lordship may look into the other implementation orders.
If he is draftsman, yes, he will be entitled to, my lord.
My lord, pharmacist, then pharmacist, page, my lord, page 56, pharmacist. Warrant officer is given, page 56. In Abhay Kumar case, page 56,
This only
pharmacist is
grants,
given.
I think, Mr. Chand, this is not regard storekeeper. This case is with regard to what? The storekeepers in this
Storekeeper.
Yes, my lord.
The storekeepers.
The storekeepers.
In the earlier judgment also.
My lord. Which is pending with the division bench, my lord.
No, page, no, this one, does it pass by the
195.
division
195, my lord.
195.
The one starting from 195.
95.
Sorry.
And very detailed judgment, my lord, everything. And my friend was there in there also before the single bench.
How can we deny them? The only problem is that I'm sitting in the division bench. That's the only thing that's in my mind.
But Havaldar can be, my lord, but warrant officer cannot be, my lord.
This argument he is making for last 5 years. And everywhere he has failed. Before the single bench, before the division bench, before the Supreme Court.
Because this judgment covers this case totally. Yes, you can't deny that. Correct?
My lord, I'm only trying to distinguish, my lord, that office...
That distinguish you have to do before the division bench.
Yes, my lord.
That's what, not here. That's what this court keeps on saying. Like Justice Banerjee sits on like a broken record, again and again repeating the same thing.
So, my lord, what I am submitting, my lord, since this has not attained finality, my lord, the one which squarely, they are saying it squarely covers them, my lord.
That's under appeal.
That is under appeal, my lord.
Take down Mr. M. Chanda, Learned Counsel Petitioner, has submitted that in line with the judgment of the coordinate bench of this court rendered in WPC number 49 and WPC 127 of 2017, nothing remains for consideration in the incident application, as much as the petitioners in both applications are similarly situated with the petitioners in the aforementioned petitions. Stop. He further submits that the respondent authorities therefore are bound to implement the orders. The first submits as the respondent have implemented the orders with regard to the other storekeepers. Stop. They be directed to afford the same benefit to the petitioners herein. Stop. Next paragraph. Dr. N. Mozika, Learned Counsel Petitioner, has submitted that the judgment referred to by the Learned Counsel Petitioner is presently under challenge by way of appeal number
45. 45 of 23, my lord.
45-23, and the matter is due for hearing. He submits that in this view of the matter, as the points in contention here have been assailed in the writ appeals, the matter be kept in abeyance to await the outcome of the decision in the appellate court. We'll hold it for 2 weeks or for 4 weeks. Then after we'll this court has perused the judgment relied upon by the Learned Counsel Petitioner and is in agreement that the judgment squarely covers the case of the British hearing. However, in consideration of the prayer of the DSGI and interest of justice, that these matters appear after 4 weeks. Next week we'll decide, because next time we get that matter heard fast.
This argument for last 5 years he is making before the single bench, division bench.
In these cases, you don't have to look at the facts of the case. Even the court don't have to look at the facts
Yes,
of the case
madam.
anymore.
Yes, madam.
39.
Obliged, Your Lordship.
Where's the judgment? Are the judgments covering this case?
Yes, Lordship did page 34, my lord.
This is also covered matter.
Yeah, covered matter, Lordship. Because here also they themselves.
The this court itself, where is that?
Yes, Lordship. Page
There are
34.
Three judgments. My lord,
Page
the
34, Annexure 9 mainly. Annexure 9, page 34.
He's quoted three
It's a very
judgments.
similar situated case.
Page 34.
Lordship. Relevant person, here also they have provided that para 1 where Mr. Hampton.
Well, this case is, my lord, not related, my lord. It will not have any relevance in this case.
Now, when did the petitioner join service?
Petitioners joined in service, Lordship, that is on 19 December 1986. First, he was as a LDA.
In the school?
Lordship.
Where's upon order?
Page 18, my lord, that is type copy. Annexure 1, original copy is 17, the type copy is.
Then it comes under zone.
Yes.
5 years before 19, that they cut off here.
Yes.
Well, the only difficulty, my lord, is what we have stated is that, my lord, there is, in the Act itself, there is no such provision, my lord.
For what?
If I take, my lord, to the
That
Act, my
Act is
lord,
only
the
the-
Act
with-
of taking out of the.
That's only for teachers, but
Yes.
that's extended to.
Yes.
That's extended to the staff also.
Yes.
My lord,
There's not a judgment. Where's the judgment? The first judgment with regard to staff.
Staff. This one also is a staff, Lordship. This.
Well, my lord, here also, my lord, the first judgment my friend is referring to, my lord will kindly see, here is a case where the names have been forwarded, my lord.
No.
Even
No,
here
look
also.
at that, look at the last judgment.
Last judgment also, my lord, it says.
Yes.
This
Large
is, my lord,
judgment. Even he also is not a teaching. He also is a staff, not a teaching. This one, not a teacher. Of course, it is referring not to be taken as a president, but he already got it, Lordship. Very similar situated case.
See, this one, you look at para 3 at page 40.
Yes, my lord, the petitioner as per submissions have been serving for over 30 years in the said school, but no pension and other retired benefits were accorded in view of the fact that the state respondents, by the proposal dated 3rd August 2012, had provided the non-teaching staff to be eligible for consideration of payment of pension benefits, etc., were to have completed at least 5 years of qualifying service as on
Have you
June
annexed this letter
1994.
also? Have you annexed this letter?
My lord?
In
No.
your affidavit, have you annexed
No,
this letter?
no, my
Then?
lord. I have not annexed. This is the letter. This is brought on record by the
from
petitioner.
where
my lord.
you see, the only thing that cut off was that fine for a person of pension if it served 5 years before it was taken over by the government, the schools, the non-teaching staffs will be eligible for payment of pension. Now he will never regularize also.
No.
No, my lord. His initial appointment itself is as a substitute teacher, my lord.
And thereafter I was promoted.
No, until and unless it's
Substitute teacher?
Yes, my lord. My lord will
Not
kindly see.
substitute teacher.
Yes, my
No.
lord.
That's the appointment, yes. Where is it?
I am not a substitute teacher.
Yes, my lord. My lord, kindly see the typed copy at page 18, my lord.
Not substitute teacher, leave substitute.
Leave substitute.
It is
LDS
appointed
is-
as thing. Is appointed.
LD as LD assistant, not
Yes.
substitute teacher. It's
86.
very clear.
Then
Vice, my lord will kindly see. Vice Shri so and so, promoted in the scale of.
no, fine. He appoints early assistant. He's appointed in 86.
As LDA. And his name also, my lord, is referred by the government for regularization, the page, annexure 8, page 32. Very similar situated with the other.
Now. And he was absorbed in diet also DIT.
That is there, my lord.
Then
My lord,
how is
if-
seeing that? How is seeing that he is appointed substitute teacher? There's no substitute teacher at all anywhere here. Substitute teacher and the leave vacancy is totally different.
So, my lord will kindly allow me some time. I'll also get some
What
clarity on
committee
this
is
matter, my
pending,
lord.
lordship,
It can come next week, no problem.
you know,
Next
see,
week
because,
or week
see,
thereafter.
Yes, the case, the petitioner appears has been appointed as non-teaching staff in which school is this?
He was not appointed in any school, my lord. That is the point.
Oh, very good. That makes his case stronger.
Yes.
My lord will kindly see.
Administrative division.
Yes, yes.
His initial appointment is
Office Administrator.
Office
yes.
of the Administrator, my lord.
Yes.
Administrator. So it is very clear.
That is absorbed in. He was absorbed into DIET.
Yes.
Well, firstly, my lord, his
He'll be happy to regularize. Yes.
my lord, his
Anyway,
service
we'll give you 1 week's time.
until and unless his service is regularized, my lord.
That's why he's asking for regularization.
Yes,
It's
yes.
like
Yes.
post facto.
Yes.
My lord, I kindly allow me a week's time.
This will be lordship. My humble prayer. This will be unnecessary delay
Yes,
because
after 1 week,
he has
we'll
been
dispose of
suffering.
all. We know what orders are going to come. He'll regularize all consequential benefits.
Yes.
Yes. He retired from diet only. Possible for us.
Yes, Asak.
In fact, my lord, the orders of this honorable
Right.
court itself, my lord, it says that it will not be a precedent, my lord, for the other cases.
No, this is a totally different case.
Yes.
Those judgments will have no bearing in this case. The thing is that he was appointed, absorbed. There was regular appointment by the district council and by the administrator. Then later on, he was absorbed into the DIET. That's the directorate, the District Institute of Education and Training, which is the government entity, and he's working
That
there
is-
as accountant come cashier. They retired.
That is there.
And can the person is given the best years of his service, you'll deny him a pension.
That is
in
there.
the end.
So kindly allow me a week's time.
Mr. Keep, I'm hearing at some length, Mr. Keyboard Shaji, please give about 1 week's time. This the matter after one is a fixed matter. Yes.
Much please, lordship.
40.
Yes.
Which is, Lord, this is that matter pertaining to that boxer, my lord, wherein, my lord, in the matter he was denied permission to even sit for the selection trial.
Yeah.
My lord, I have gone through the affidavit filed by them, especially the paragraph at...
Filed by whom? By
the
MSP Barasaji?
Yes.
On behalf of?
Yes, on behalf of
3 and 4.
Meghalaya Boxing Association. The state has declined to file any affidavit in this regard. My lord, he appears to be the person filing appears to be the president of Meghalaya Boxing Association. I take your lordship directly to paragraph page 8, paragraph 9. This is I'm referring to the second paragraph, my lord, of page 8. My lord, it is never a case. My lord has got it.
Yes.
It is never a case that the petitioner was disallowed or denied to participate in trial for any event, but being a competitor organization, can the petitioner, without any NOC from the concerned department, participate in a trial where the ultimate goal will be contesting with the different competitors? Not only the factum of NOC not being there is wrong, my lord. There is already an NOC which has been annexed with the writ petition. Further, the petitioner never participated in the trial to get...
What is this mare? No objection. What's mare? Mare's a horse.
Right, no. But there's some...
Who does this affidavit?
It has come from the respondent, my lord.
The spelling mistake is there.
What's my mistake? This is here committing violence in the English language. Even see they don't know present tense and the past tense.
It should be.
It's not a case which was disallowed.
It should be disallowed.
This could come in, but being in a competitor, I don't understand this. Who vets these affidavits? It's vetted by whom? Why committing so much violence against the English language? Look at this. I mean, what's Assam rifle?
The petitioner is presently working in
No,
Assam.
is it called Assam rifles? Even these basic things, rejecting this affidavit. Unless you correct it. An affidavit in opposition had been filed by the respondent 3 and 4 since 14/11/2024. Stop. An examination of the same. How will you correct the affidavit now? I don't understand what Paris is saying. It is never a case that a petitioner would disallow or deny to participate in trial or any event, but being in a competitor organization. What becomes can the petitioner or any NOC from the concern? It should be ED department participate in a trial where ultimate goal will be contesting with different competitors. Further, the petitioner never participated in a trial to get himself selected for the event. Mere no objection does not qualify an event. The petitioner. We can't overlook this kind of when you draft an affidavit and you file it for the court, it's just a total disregard to to the language and what it seeks to.
Lordship, I'll just draw Lordship attentions to the to one of the annexures, Lordship. Lordship.
Yeah, I think it'd be better. We not look at the pleadings.
So many grammatical errors.
Lordship, I'll just draw Lordship attentions to page number 37, Lordship.
Yes.
Lordship, here he has been appointed as a coach, Lordship. Now presently he is the coach of Meghalaya, boxing coach. In serial number 1, his name is reflected.
Okay.
Lordship, being a coach is a teacher, Lordship, in our our understanding, Lordship. So being a coach, whether he can participate, Lordship. Furthermore, Lordship, if I draws Lordship attention to page number 29.
Well, I'm sorry to interject, but the page number that she is referring to doesn't match with my page number, Malad.
I think you'd have to pay cost. What is 29?
In my page number 29, it is something else, Malad. What in page 29?
Elite men's boxing.
No, Malad. It is boxing medalist men.
Boxing Association.
The one which she is referring to stands at page number 27 in my writ petition. I mean, in my copy, Malad. The one which she is referring to now stands at page number 27 in my.
Rising
copy.
Star Boxing Association.
Meghalaya Boxing Association, Lordship, annexure 5C, Lordship.
How are you conducting cases? I don't understand.
Annexure 5C, Lordship. Here, this letter is 27 September, 2nd September, letter date is 2nd September, Lordship. And
did he participate in the selection?
No, Lordship, that is why he has not participated.
Why?
Well, they deny this aspect. My lord, obviously we would not have any evidence to prove that we went for a participation and we were disallowed.
Lordship, the name
My
of the
lord, that is why, my lord, I was referring to that paragraph. Lord, if your lordship pleases, Lord, this matter can be disposed of by directing that in any future event, if I am subject, if I make myself subject to trial, my lord, then I should be disallowed. I should be allowed.
Lordship, being a coach now, Lordship, and moreover,
Coach can't play anymore.
Lordship, he is.
Show me the rule that says that a coach can't play or can't take part in competitions.
Lordship, he is participate. He is giving trainings to the people. Lordship,
no, doesn't matter. Suppose, show me where is written that once you're a coach, you can't be a player. Where's that? Show that rule.
Lordship, that rule I don't have, Lordship.
You will not have it because there's a tradition. Even football, they have player come coaches.
Lordship.
And you have drafted the affidavit. I mean, you have not bothered to check even the tenses of the sentences.
I apologize, Lordship.
You've not checked it.
I apologize, Lordship.
You're very busy as a counsel. How busy are you? That you can't even check the affidavit has been filed. You see, you have the question is not only of your own, maintenance of standards. It's a question of having, the regard and respect for your counsel for the court in the kind of petitions that you present and the language that's used. What it seeks to convey must be clear. You spoil, you see, the court becomes, it's a question of, it becomes inimical to your own, your case. I mean, the way the drafting of the affidavit is atrocious. Read from the first paragraph. This kind of affidavit you file before the court. The respondent number 3 is only dedicated to health athletics, good athletics, developed skills. Supporting athletic, what do you mean by help athletics and support athletics? Look at para 3. I'm presently holding what? Look para 4. What we present, sir, respond to peruse the same. We have understood the content. Yes, what do you say? Dispose how?
Well, I was just referring to that particular paragraph, my lord. If that is noted, my lord may dispose it of by
paragraph.
That paragraph 9, my lord.
We can't understand this in paragraph 9.
All right, my lord. That is the difficulty.
Stop. Me. The petitioner being aggrieved with the action of respondents 3 and 4. MS Pure, what is the meaning of pugilist? Yes. What's the meaning of pugilist? Who's a pugilist? You're representing the Boxing Federation. Who's a pugilist? You don't know.
No, where I use the
A pugilist is a boxer.
Yes.
That's there in the synopsis of their writ petition only. It's really, I don't know. I feel very sad that that is a standard of, yes, in not allowing him to compete in the selection trials and other boxing events to represent the state without any reasons being ascribed, has approached this court with the instant petition against the arbitrary action of against the alleged arbitrary action of the respondents. Stop. Next, by Ms. S. Thapa, counsel for the petitioner, has submitted that the petitioner, who is serving in the Assam Rifles, has sought permission from his employer for an NOC to allow him to represent the state, which was granted wide certificates dated 4 and 5. Certificates dated
4 and 5.
Dated
in the second permission, the date is February 26th, February 2024.
21 to 2024, which has been annexed to the writ petition. He further submits that, having obtained the said NOC, the petitioner had approached the respondent authorities for consideration and for trial as a participant, which however was not allowed without any justification being provided. The action of the respondent 3 and 4 is submitted is totally without any cause or reason, and has resulted in the writ petitioner being deprived of an opportunity to further his sporting career and to represent the state. Stop. He never prays that appropriate directions be issued to direct the respondents to furnish the reasons for denial of opportunity, and also for directions that they be directed, the authorization that he be allowed to compete in the trials for future events. Stop. The respondents number 3 and 4, that is the Meghalaya Boxing Association, which is represented by MSP Bharat Savji, have filed an affidavit in reply to the writ petition. I find after opposition. Stop. Before alluding to the submissions of the counsel, this court is constrained to note that the affidavit is intelligible with grammatical mistakes that have overshadowed the entire pleadings or what it seeks to convey. However, from the submissions of the learned counsel, it is contended that the writ petitioner was never disallowed from or denied to participate in any selection, but that the denial was due to the fact that he was not in possession of an NOC from the Assam Rifles. Stop. It is further submitted that as the petitioner is also a coach, he will not be eligible to put himself up for selection to take part in competitions.
As per the IBA rules.
Where are the IBA rules?
IBA rules, it is, I have not enclosed here, but
where is it?
It is there, Lordship. IBA rules is there that once a person.
Where is that? Why have you not brought it? Where are the IBA rules?
IBA rules I have not enclosed, Lordship, but as per the IBA rules, it is there, Lordship.
So the coach will take part as per the IBA rules. However, the rules have not been annexed nor have a copy of the same been submitted before the court for consideration. Stop. Next paragraph.
My Lord, I'm sorry to interject. Besides that, my Lord, the annexure that she is referring to, Lord, it is only with regard to his admission for the cause of a coach.
Yes, coaches is as per IB rules. This submission has also been refuted by Mr. S. Thapa, who submits that the concerned annexure, where is that?
Page 37.
Page 37, referred to by the learned counsel for the petitioner, only shows that he has been.
Well, he has taken an admission for the course.
That the petitioner has taken admission for. Where is it given?
Well, it is borne out by their statement at page 7.
For training as problem on this matter? Has sought admission for training as the sport, for training as a boxing coach, but he's already selected.
Yes, Lordship, he has already. He has been certified with this, Lordship. Page 37, page number 37. His name is already there, Lordship, as a coach.
No.
From the institute, Lordship.
Whether he has passed out successfully, my lord,
It is
that
Department
not
of Sport Management Coaching. It is already reflected there, Lordship.
Because this, as per them, my lord, it's in an admission list.
He's completed as a coach.
Lordship.
Now, my lord, may kindly see page 31, list of provisionally selected candidate.
You get instruction in Thapa tomorrow. Next,
my lord, page 30.
Necessary. List this matter on Friday. On Friday, Monday. You take it very complete the coach on. And you bring IPA rule.
Lordship.
42.
Well.
And we draft affidavits. When I was a counsel before, I might have been senior counsel. Every pleading drafted by my juniors, I have to check them minutely. You don't even bother to do that. Are you so busy as a senior counsel? How many briefs do you have? Hundreds? Thousands? You just file it mechanically.
I apologize.
Next time it pay heavy cost. This is not the first time this happened in some of your cases. It's not, you're not a competent lawyer.
I apologize.
Yes. Yes.
May it please your lordship. Your lordship, I pray for accommodation in this matter, your lordship. The
Why?
GI is on legs, your lordship, before division bench.
Yes, who's for the petitioner?
She's
The GSGI is not available right now.
Please, Lordship, they my prayer is not now very limited because in the counter affidavit, they have evidence that out of 10 6 vacancies for the general category, they have paid only 5 and 1 was cancelled.
No, see, here MS Lamba, right?
Yes,
The DSI is not here. We'll have it after 1 week. Yes, as the DSI is not present, a prayer meeting we have for listening the matter 1 week. Accordingly, that matter stand over for 1 week. Yes.
Highly obliged, Lordship.